Hello guys, good afternoon, good evening, good morning, no matter where you're watching me from. Guys, there's a good news. There's a good news because I I saw one video where one lawyer was explaining how how Peter Obi will definitely win our mandate back. I'm very happy because this is a good news. It's a good news. This is a good news, guys. This is a fantastic news. I saw the video and I was so much interested in the video. So I made a copy of it. And please, you check the video after this video. So you'll see the video and you will watch the video to the end, and you will see how this senior lawyer explain how Obi would give us our mandate back. So I'm very happy about the video. So guys, make sure you watch this video till the end. This lawyer explained everything. Okay? So, if you did not get 25% in Abuja, you cannot be the president of Nigeria. So, that's the fact. If you did not get 25% in Abuja, you cannot be Nigerian president. Simple. So now we have hope. We have hope. There's hope that Obi will be the president of Nigeria. Obi will be the president of Nigeria, no matter what they are doing right now. But he will definitely be the president of Nigeria because the lawyer has explained details about the law. So if you want to be a Nigerian president, you have to have 25% in Abuja before you can be Nigerian president. So I was so very happy when I watched the video. Guys, I want you to join me to watch this video and give your own opinion, what you think about the video. So guys, you just to watch the video I'm about to play.
There's a context in which I've recommended that we should finish the petitions as fast as possible, and I think 7 days is a good time to go. The fact that the Constitution prescribes a time limit doesn't mean that that time limit must actually run. So the context of my call is that the polity is overheated. The other day, the Minister of Information is accusing Mr. Peter Obi of treason. People want interim government. There are all kinds of things going around. There's a whole shebang of things that seems to want to destabilize Nigeria. The DSS is shouting that there are people who are all over the place doing things. And the simple problem is just to resolve the election petitions. So the question is not whether it is doable, it is whether it can be done. So I start by saying that the judicial philosophy of Nigeria is about 100 years old. Nigeria is not known for speed. Why is it possible that Ghana finishes its own election petition in 30 days? So why can't we also do it here? Why should we have 360 days to do something that is fairly simple? So the new international gold standard, and I sit as a senior arbitrator in the City of London, and what we do is we apply case management. So my first recommendation is to say, the issues presented to the tribunals, are they amenable to quick resolution? And I think there are three issues which you've outlined that are amenable to quick resolution, one way or the other. Now, under the Kenyan procedure, those questions that I've set out are decided in exactly 1 day. So if I was the presiding judge of the tribunal, I would give 2 hours to the petitioner to establish the case whether 25% of FCT is relevant in the consideration of who is the president or not. I would give time to Mr. Tinubu's people to reply, and I'll deliver a ruling at 6 p.m. What's the difficulty? These are purely matters of law. So it is absolutely feasible. If those three questions do not succeed, then the part A of the petition would be now to do what you say, take the issue of electoral malpractice, which I concede will be a lot longer. But I have a strong feeling that those three questions I have set out can resolve the petition one way or the other. And it can be done in 7 days. If Kenya can do it in 14 days, why do we need 360 days to do our own? Are we not more highly judicially educated than Kenya? So come on, and I also would, without criticizing the lawyers in the petition, since they filed the petition, I haven't heard anything from them. There's all sorts of procedures by which you can front load a case, push it, set out procedural issues, set out jurisdictional issues for the tribunal to determine. That's number one. Two, the tribunal itself can, of its own motion, suo motu, raise questions. So we've read all these petitions, and we think we can dispose of this petition if we set out some questions that, if taken, can resolve the entire thing. I'm concerned that the politics is overheated, and the way to go is to see if we can get the petitions resolved before May 29. The elections were in February. That's about 4 months. What's the difficulty about resolving these cases well before the handover? Kenya has a procedure whereby they lay out a policy. There shall be no inauguration until the petitions are complete. And in the Wheh panel, which I was a member, we set out that procedure. There's a certain unfairness for a petitioner to challenge the president-elect who goes on to get inaugurated. That's what's causing all the problem. So let's give it a go. Let the judiciary give it a go. Let the lawyers in the tribunal give it a go to see whether we cannot accomplish what I've described in my letter. So that's the basis of my letter.
All right.
Well, the timeline. Nobody waits for the end of the timeline. Once you file your petition, you should be ready to make preemptory strikes. So if I was in the petition, I filed the petition on Monday. On Tuesday, I will file all my papers and request the court to determine certain jurisdictional questions. The fact that I have 180 days doesn't mean I should wait to 179 days to then begin to hustle. Everybody agrees that the politics is overheated. So we need speed.
Okay. All right, so that brings me to my question, Dr. Bakoba.
Of the petition,
yes.
Case management philosophy. There are steps you take to arrive at a conclusion. So step one would mean that if the decision of the tribunal states that 25% of FCT is not required, that point fails. If the tribunal says that 25% of FCT is required, then the petition succeeds. Now, so as you go up the steps, you will come to the point where the most difficult question will be posed, which is electoral irregularity. Mr. Robert Clark was on your program yesterday, and he gave a description of how petitions work. Petitions work on two levels. The first one is the technical level. All the 3 points I laid out, they are jurisdictional, they don't need any facts. You don't need a single documentation from INEC, because on the facts, Mr. Tinubu did not win 25% in Abuja. So you don't need any access from INEC. It's stated in the petition. So the question is a legal question. What is the consequence of Mr. Tinubu not getting 25% in Abuja? Is it fatal or is it not fatal? You don't need any recourse to INEC for any documentation. If the question is answered in the negative, Tinubu goes through. If it's answered in the positive, Tinubu loses. You go to the next question. What is the consequence of Mr. Tinubu's vice presidential candidate being on the ballot of senatorial? Is it fatal in view of Section 35 of the Constitution, one way or the other? And so on and so forth. So you exhaust the jurisdictional and procedural questions. If all those questions succeed, then you are within the time to dismiss the petition or allow it. Now, the more difficult one is if the procedural and jurisdictional points do not succeed. Then we're bogged down by the electoral irregularities, and I agree here that access to documentation will be necessary. But to sit down and do nothing, I haven't heard a thing from the courts, I haven't heard a thing from the legal team, is the point that I'm saying is irritating. And the politics is overheated. That day, Mr. Lai Mohammed was in the UK, in the US, shouting treason. Mr. Tinubu, Mr. Peter Obi is here making his own war. But we can resolve all this and have peace if the petition is decided one way or the other on technical points. If it fails, and I take the point that it's possible that it will fail, then we go to step two, which is evidential hearings.
Well, you recently...
Tinubu should not be president on the basis that he didn't win this. Tell me why. Do you need 20 days to do that? You don't need 20 days. It's a legal question whether "and" in Section 134 is contiguous or not. It's very simple. A bench ruling can be given on that. I've done big arbitrations in the City of London and decided the point in 3 hours. So there's nothing that... You see, the problem is our judicial philosophy. I'm just looking at the Kenyan one. It says here, sustaining judiciary transformation. That's the Kenyan one. Sustaining judiciary's transformation. How can this country, the so-called giant of Africa, run a judicial system that is 100 years old? That's the problem. The NJC is not doing anything to create a new... Yes?
I get that point about best practice. Well, I would like to know whether you got a reply.
Yes.
And then as a senior advocate of Nigeria, what's your own opinion, which you have not documented, about the interpretation of that section 134, sub 2 in particular?
Well, I did a letter to INEC, and if they had answered me, maybe you wouldn't have been in this logjam. But I had an interview. They didn't reply, by the way. But I had the closest they came to reply was an interview I did on TVC with my good friend Festus Okoye, and he admitted that it was an issue that required to be resolved. And I was surprised that they did nothing. My own view is that Section 134 applied literally, because the rules of interpretation say if you read something and it's so clear to you, then you don't need to interpret it. The thing says you must win a quarter of the votes in 2/3 of 36 states. And so what do you want to say? The answer is obvious.
So the presidential candidate does not have to get 25% in FCT. Otherwise, it will amount to an absurdity. If he already has 25% in, say, about 28 states.
No, I didn't say that. I said
no, I want you to break it down.
25%.
I want you to break it down in a way that the ordinary
man... I've just broken it
down. No, let's apply
I've just broken it down. Ruben, I've broken it down. You want to put words in my mouth, which I won't accept. It's so simple. You get a quarter of the votes in 25%, in a quarter of the votes in 2/3 of 36 states. That is what the law says, which is 24. So that's one part of it. It goes on to say, and. What does that mean? And the FCT. So as far as I'm concerned, you must also win 25% in the FCT. But that's not for me to say, because I'll be judging what is before the tribunal. So we think the tribunal can answer this question quite easily in 1 hour. That's my point. Quite easily.